Welcome to our tutorial lesson on the law of tort, episode 8. You may recall that during our 7th episode, we treated trespass to land, where we identified 6 elements to establish in order to be successful for a claim against a trespasser. In this episode, we are moving to another branch of trespass in tort, and we are looking at the tort of trespass to chattels as the area of law under tort. Today, we are going to identify the principles in the tort of trespass to chattel to help you appreciate how to apply them. What is trespass to chattel? Someone described the tort of trespass to chattel as that. The tort of trespass to chattel consists in committing without lawful justification any act of direct physical interference with the chattel in the possession of another person. This description was affirmed in the case of Forson and Coens. Trespass to chattel provides a wider cover of protection than conversion because a mere act of interference is sufficient and there is no need to prove special damage. But that is narrower than conversion because of the requirements that the interference with the chattel must be direct. What are the principles governing trespass to chattel? Trespass to chattel is actionable per se, meaning to be successful, you need not prove actual damage. Lord Blainsberg and William Leach and Leyden put it as follows: "A man touches the property of others for at his peril. Trespass is constituted whether there is actual damage or not." With more emphasis, it was held in Foltz and Willoughby that the slightest touching of a chattel is actionable. Also, in Penfolds Wines Proprietary Limited and Elliott, Latham C.J. stated, "A mere taking or asportation of a chattel may be a trespass without the infliction of any material damage. The handling of a chattel without authority is a trespass." Unauthorized user of goods is a trespass. Unauthorized acts of riding a horse, driving a motor car, using a bottle are all equally trespasses, even though the horse may be returned unharmed, or car unwrecked, or the bottle unbroken. He concluded by saying, "The normal use of the property for any purpose is a trespass if it is not authorized by a person in possession or entitled to immediate possession." However, in the New Zealand case of Everett and Martin, it was held that an intentional interference with a chattel without asportation is not actionable unless there is harm. To remind you, this is the case where the defendant hanged his coat on the plaintiff's dilapidated car. So if you sit in one's car and he says you should drop and you refuse, you may be found liable. In all, as reaffirmed by Raymond C.J. in Slater and Swan, trespass is actionable without proof of damage. Who may sue for an action of trespass to chattel? In other words, what is the relationship that should exist between the person suing and the chattel interfered with? In Ward and Macaulay, Lord Kenyon C.J. said, "To maintain an action in trespass, the plaintiff must be in possession of the property at the time the property is interfered with." Also, in Wilson and Lombank Limited, it was established that a person in possession of a chattel, even if he has no title to the chattel, can maintain an action in trespass against any stranger. For flying things such as pigeons, it was held in Hams and Derby that the owner of tamed or reclaimed pigeons continues to have property in and possession of his birds after they have flown from his dovecote, so long as the birds retain an animus vivendi to his control. We encourage you to share your knowledge on the meaning of the Latin term animus vivendi in the comment section. Again, assignee of goods is deemed to have possession, as Jervis C.J. in White and Morris puts it in the following words: "Where goods are assigned as security and the assignee of goods has power to sell the goods upon default, the assignee is in possession of the goods for the purposes of an action in trespass, although the assignor retains physical possession of the goods." Furthermore, for finders of goods on a premises, in the case of Parker and British Airways Board, Donaldson J. stated the principle that a person who finds a thing on the premises of another and takes it into his own care and control, acquires the right of possession of the found thing except against the true owner. Lastly, Dixon J. and Penfolds Wines Proprietary Limited and Elliott identified that, subject to the rights of a bailer, master or principal of a person, only a person in possession of goods can sue for trespass. Therefore, you have to be either one of the following to have a legal capacity to sue. 1. An assignee of goods with power to sell on default. 2. A finder of goods who takes it into his care and control. 3. A bailer. 4. A master. 5. A principal of a person. Or 6. A person in possession of goods at the time of the trespass. What are the exceptions to the rule on possession? 1. Trustees are allowed to sue for trespass to chattels in the hands of beneficiaries. 2. The title of personal representatives, such as administrators and executors, is treated by the law as relating back to the time of death of the deceased, and they are allowed to sue for interference in the estate of the deceased, which occurred before probate or letters of administration. 3. In a bailment for a fixed term, the bailer has no possession, but in a bailment at will, both bailer and bailee can sue third parties, although physically the goods interfered with are in the hands of the bailee. For bailment for a fixed term, only the bailee can sue. The bailee can sue for full value of the chattel, although there is a legal duty on him to hand over that part of the damages that is over and above his interest, as was noted in the Wingfield case. 4. The owner of a franchise which entitles him to goods can bring an action in trespass in respect of interference with the goods before he has actually taken control of them. What are the requirements to establish to be successful? 1. The major requirement is that there has to be a direct and intentional physical interference with the chattel, as put by Edusei J. as he then was enforcing in Koe. A direct and intentional interference with a chattel in the possession of another is a trespass. 2. Also remember Salmon's description. There must be no lawful justification for the interference. 3. As put by Cohen LJ in National Coal Board and Evans, the requisite state of mind needed is intention, and the act must also be voluntary. That, as emphasized by Corsa CJ in Halaby and Halaby, a person is not liable in trespass for an involuntary and accidental act. And as Justice Bramwell relayed the principle in Kirk and Gregory, an intentional interference with the property of another is actionable per se, even if the interference was done in good faith, unless the interference was reasonably required under the circumstances. Before we end, let's identify the rights and obligations of the finder of a good on a premises. 1. The finder of a chattel acquires no rights over it unless A. It has been abandoned or lost, and B. He takes it into his care and control. 2. The finder of a chattel acquires very limited rights over it if he takes it into his care and control with dishonest intent or in the cause of trespassing. 3. Subject to the foregoing and to point 4 below, a finder of a chattel, whilst not acquiring any absolute property or ownership in that chattel, acquires a right to keep it against all but the true owner, or those in a position to claim through the true owner, or one who can assert a prior right to keep the chattel, which was subsisting at the time when the finder took the chattel into his care and control. 4. Unless otherwise agreed, any servant or agent who finds a chattel in the course of his employment or agency, and not wholly incidentally or collaterally thereto, and who takes it into his care and control, that so on behalf of his employer or principal, who acquires a finder's right to the exclusion of those of the actual finder. 5. A person having a finder's right has an obligation to take such measures as in all the circumstances are reasonable to acquaint the true owner of the finding, and the present whereabouts of the chattel and to care for it meanwhile. He further outlined the rights and liabilities of an occupier as follows. 1. An occupier of land has rights superior to those of a finder over chattels in or attached to that land, and an occupier of a builder has similar rights in respect of chattels attached to that building, whether in either case the occupier is aware of the presence of the chattel. 2. An occupier of a building has rights superior to those of a finder over chattels upon or in but not attached to that building if but only if, before the chattel is found, he has manifested an intention to exercise control over the building and the things which may be upon it or in it. 3. An occupier who manifests an intention to exercise control over a building and the things which may be upon or in it, so as to acquire rights superior to those of a finder, is under an obligation to take such measures as in all the circumstances are reasonable to ensure that lost chattels are found, and upon their being found, whether by him or by a third party, to acquaint the true owner of the finding and to care for the chattels meanwhile. The manifestation of intention may be express or implied from the circumstances, including, in particular, the circumstance that the occupier manifestly accepts or is obliged by law to accept liability for chattel lost upon his premises. Example, an innkeeper or carrier's liability. An occupier of a chattel, example, a ship, motor car, caravan, or aircraft, is to be treated as if he were the occupier of a building. We will be happy to read what you think are the distinction between the finder and the occupant in the comment section below. Also, please find out what would be the measure of damages in an action for trespass to chattel and write it in the comment section below. This is the end of our 8th episode. We hope you learned and you will join us for our next episode on the law of tort. Please help us share this channel to everyone, like our videos, comment and subscribe. Thank you.